Hello and compliments of the season. Welcome to yet another insightful edition of the program, CAC Weekly, a weekly program that keeps you abreast on the activities and achievements of the Corporate Affairs Commission. My name is Amina Jibril. And we start off with the cheering news that the International Criminal Police Organization, Interpol, has recognized the role of the Corporate Affairs Commission, CAC, in the fight against crime and crime-related activities. The recognition culminated in the presentation of an award for excellent partnership and collaboration in the fight against crime by the Interpol to the Commission. The presentation ceremony was held in Abuja on the 19th of December 2020 to commemorate Interpol's end-of-the-year party and award night. The Registrar General and CEO of the CAC, Alhaji Garba Abubakar, represented by the Deputy Director, Intergovernmental Affairs Unit, Mr. M.Y. Aliyu, FSI, received the award on behalf of the Commission. Alhaji Garba Abubakar thanked the Interpol for the award and stressed that the gesture would no doubt spur the Commission to continue to offer selfless service to the nation. We say congratulations to the CAC family. And now moving on to the continuation of our efforts to further dissect the CAMA 2020, its implementation and impact on businesses, we shall today take a look at key innovations such as the limited liability partnerships, LLPs, and limited partnerships, LPs, the beneficial ownership, and the ability to curb corruption and money laundering. But we will be right back after this break. To stay with us. Welcome back. Aside from ensuring transparency and accountability in governance, the Companies and Allied Matters Act, CAMA 2020, is poised to develop in the private sector and democratize the process of doing business in Nigeria. The CAMA 2020, the game changer as it is often called, is poised to further enhance and facilitate trade and investment in the country. The CAMA 2020 has 870 sections which are classified into chapters on the parts A to G. While Part A deals with the composition and administration of the registry which functions as a regulator, Part B has 29 chapters which stipulates the life cycle of companies from their incorporation through to liquidation. Part C and D have 11 and 2 chapters respectively and set out provisions that govern limited liability partnerships, LLPs, and limited partnerships, LPs. Parts E and F reprised sections on the registration and regulations of business name and incorporated trustees, with a few changes outlined in chapters 3 and 7, respectively. Part G introduces the quasi-judicial body. Now, quasi-judicial body, for the benefits of some of our viewers, according to Wikipedia, it is defined as a non-judicial body which can interpret law. It is an entity such as an arbitrator or a tribunal board, generally of a public administrative agency which has powers and procedures resembling those of a court of law or judge, and which is obliged to objectively determine facts and draw conclusions from them so as to provide the basis of an official action. Such actions are able to remedy a situation or impose legal penalties, and they may affect the legal rights, duties, or premium of specific parties. Now, CAMA 2020, an important milestone for the business sector, removes substantially a significant number of bottlenecks that hitherto prevent market penetration of micro, small, and medium enterprises, MSMEs, and significantly reduces the reporting obligations and requirements that may ordinarily inhibit the growth of the MSMEs. One of the key innovations of the CAMA 2020 is the introduction of limited liability partnerships, LLPs, clearly spelled out in Section 746 to 794, and limited partnerships, LPs, in Section 795 to 810. These two injunctions contained in Part C of the new Act are not only new and fresh, but provide great opportunities for businesses. Speaking with CAC Weekly, the Assistant Director, Registry Department, CAC, Mr. Tolulope Adiola Shonaike, explains further what limited liability partnerships, LLPs, and limited partnerships, LPs, are all about, particularly their differences and potentials for the Nigerian economy.
today we're going to be talking about the Part C of the new law, which deals with the limited liability partnership and the limited partnership. We do understand that under the new law, Section 746 to 794 deals with the limited liability partnership. So for the purpose of our viewers, maybe you just help us break it down, help us understand what the limited liability partnership is all about.
Before now, there was no such provision in the Companies and Allied Matters Act of 1990, but the new act, that the 2020 Companies and Allied Matters Act, has introduced that entity, that business arrangement called the Limited Liability Partnership. The Limited Liability Partnership is an alternative corporate arrangement for businesses. In many respects, it's just like the private limited companies. And in some other respects, it still enjoys the benefits and the advantages of a partnership. What we need to understand with the limited liability partnership is that it is a body corporate. In other words, it's different from the partners, just like the company, which is different from its promoters. So for all the partners in the limited liability partnership, that's why it's called a limited liability partnership. There are liabilities, exposures in cases of debts, or liabilities of the partnership is limited to that aspect of their contribution, what they have undertaken to contribute to the partnership.
Okay. So what is the difference between a limited liability partnership and a limited partnership? We also understand that under the new law, Section 795 to 8110 deals with limited partnership. Let's understand what limited partnership is, then we'll now begin to talk about the difference between the two, because people will say it's partnership after all.
That's true. Partnership is partnership. Well, that again is a simple way of looking at it. Don't forget that I said earlier that for the LLP, that's the limited liability partnership, it enjoys what you call corporate personality. Now, in the case of a limited partnership, it does not enjoy what you call corporate personality. And in the case of the limited liability, the limited partnership, you must have a general partner, at least one, and you must have what you call the limited partner. Now, that limited partner is the only one whose liability is limited in that arrangement. The liabilities of the general partner for debts of the company is not limited. In other words, if the situation so arises, the general partner would have to be responsible for settling the debts of the partnership, and if for some reasons the contributions are not enough to do that, you can actually move against him personally, using his personal assets. But that is not the case in the case of limited liability partnerships. So you'll find that for the limited partnerships, it's ideal for small companies, small businesses, enterprises, or for those who, like you say, want to test the waters before going fully into it. Partnerships generally. When you say, just say partnerships, you're referring to general partners. Okay. Now, general partners are the ones that are responsible for the management, for the running of the business. And their liabilities are not limited. In other words, they can be personally liable for the debts of the partnership. When I say personally liable, it means that if the assets of the partnership is not enough to settle the debts, we can actually proceed against you personally and take your own assets, personal property, to settle such debts. Now, for a limited partnership, you must have one person that must be able to play that role that you can hold. For statutory compliance, that is required, the obligations to file papers with the registry, that's CAC. It is the general partner that is responsible for maintaining records, for filings, and all of that. Then you have the limited partner who just brings his money. He's just an investor. And he says, okay, this is my money. Let me join you in a partnership to promote this business. Now, ordinarily, the limited partner is not liable for the debts of the partnership beyond his contribution to the business. But when he gets involved, that benefit no longer avails him. When he gets involved in running the business, then he's also liable personally. On the other side, the limited liability partnership, like I said, you need at least two people to start it. And that is because you must have at least two designated partners. Now, designated partners are to limited liability partnership what directors are to companies. The designated partners are those that are responsible for the day-to-day management of the of the partnership, limited liability partnership, and for, again, filing statutory returns, compliance issues, and all of that. The only difference between the LP and LLP here is that for the LLP, all the partners have their liabilities limited. So, and if for any reason the number of designated partners falls below 2, then every other partner is deemed to be a designated partner.
Okay.
So you must, once you have the number falling below 2, the law requires that within 30 days, you must appoint another designated partner to fill that point. Now, whether for an LLP or an LP, a corporate body may be a partner. For the limited partnership, a corporate body, just like the business names, may be a partner directly. Right? Same thing for the limited liability partnership. But a corporate body cannot be a designated partner. If a corporate body must be represented as a designated partner, then it must appoint an individual to that office, to be the designated partner. The purpose of regulations, compliance, and all of that, the designated partners are responsible. And in the case of the limited partnership, you have the general partner responsible. Now, for the limited liability partnership, let me say one thing. It has this advantage of combining the benefits of corporate personality. When I say corporate personality, that means a person that the law recognizes different from those that are promoting the business. Now, it has that benefit. Once you register as a limited liability company, you become a body corporate, different from the partners. Now, it also has this advantage of combining the flexibility of a partnership.
Okay.
So you'll find that between the company per se, that's a private limited companies, and the limited liability partnership, the limited liability partnership is more flexible in management. There are several things that are not prescribed by law, but that are strictly regulated by the agreement of the partnership. Whether for a limited partnership or limited liability partnership, it is regulated by agreement. There is a partnership agreement. So things like the mutual rights of partners between themselves, or partners and the partnership itself, they are regulated by the partnership agreement. Removal of a partner, introduction of a partner, all these things are regulated by the partnership agreement. So you find that the threshold of regulation, the burden of regulation, is actually lower compared to that of a company. On the company, on the other side, there are several rules, extensive rules in the company that are regulating its management and administration. But that does not apply to, most of those don't apply to the limited liability partnership.
Okay. What would be the requirements to go for any of these two?
There are template forms, application forms that were designed, and it will be online. The requirements will be the basic information that you will need, because CAC is a repository really of information on these entities. You don't bring money here; it's just information we keep. So to register either way, whether for a limited partnership or a limited liability partnership, you'll be required to provide the full details of the partners, their addresses. You'll also be required to accompany your application with the partnership agreement. Now, where there is a default partnership agreement, there is a template in the Act, Schedule 15, where you think it's okay, you don't need anything complex, you can adopt it. And then you have to have a registered business address in Nigeria. Of course, we will need a means of identification, a photo means, of identification. Any of the recognized means of photo ID, perhaps the data page of your traveler's passport, your driver's license, your national ID card, and even your voter's card will require all of that. Okay. And right now, the regulations have been put forward to the minister, and we are waiting his approval on it. But what is proposed as fees for registration for a limited liability partnership is 20,000, and you have both the certificate and the certified extracts, copies of the information you have provided. For the limited partnership, it's 15,000 naira.
Okay. For some people, will it be the same thing as a business name? The limited partnership, is it the same thing as a business name?
Yeah, some perspectives, yes, but not exactly that.
Okay.
For a business name, there's
an
no
upgraded level of business
well,
name.
maybe with some yes, upgraded in the sense that it now introduces some limitation to liability.
Okay.
For a business name, the liabilities are strict. There's no limitation to liability.
Okay.
But for limited partnership, there is one partner that has limited partnership. And again, because it's a partnership, you must have at least 2 people. For the sole proprietorship, you have to go under business names.
So in the case of insolvency, what happens for the limited liability?
Limited liability partnerships, right? Before you even get to that point, there are also provisions. The provisions on investigation that applies to companies also applies to limited liability partnerships. Again, for limited liability partnerships, even though it's not so expressly provided in the law, they can borrow. And I believe that bankers will not give you money without that clause on receivership. That when you start having problems, they can move in to try and mitigate their losses, recover their money. So you'll find that those rules will still apply in the case of limited liability partnerships. Okay.
We do understand that there are new injections into the law, the limited liability partnership and the limited partnership. At what point did they become important to be included?
It was our experience that some states had started registering limited liability partnerships and limited partnerships. These were responses to the demand for these entities. It's not like they didn't serve a purpose. It was clear to us that people, investors, needed these services. They needed to be able to do their businesses using these forms. But for the limited partnership, that shouldn't have been a problem because partnership generally, because it's not a body corporate, partnerships generally are regulated by state laws, and the Partnership Act of 1890, by virtue of the Statute of General Application, is applicable in most of these places. Some people reenacted it, some people fine-tuned it and updated it. But partnership generally is regulated by states. Now, when it comes to limited liability partnerships, because you are now talking about creating body corporates, limitation of liabilities and recognition of persons in law created by instruments of the law. Now, these are matters that are strictly within the purview of the federal government and federal legislature. So that was why it was necessary at that point to address that matter. If people are craving, if people are demanding for these forms of entities, if they so desire them for businesses, then we should be responsive to that. We should be seen to be creating and making it available for them to, and making it, not creating a situation where people will be forced to take actions that will violate the law. I'm sure if these entities had existed under the law, right, those states it would have been difficult for them to introduce it, because our experience also was that after registration in those states, people still come back to CAC with those certificates and say they want to register under CAC. Because for them, it's they believe that registration with the Corporate Affairs Commission gives you a national
outlook.
Yes, outlook.
Would there be a conflict of interest between the commission and the states?
Yes, I think for now, the states have stopped that. For a while now, they don't do that anymore. For general partnerships, like I said, the state laws regulate all of that. But for limited liability partnerships, I do not think any state does that anymore.
For those who have registered before now with their state, and what happens to them within the new law?
Well, as it were, they have to come and pursue another registration, as it were, because they are not registered under the Companies and Allied Matters Act, and so they cannot take advantage or enjoy the benefits provided by that law. So
that previous registration becomes invalid?
As it were, I mean, it's just like going to say you register a company in a state. I mean, if it cannot stand, it cannot stand.
Okay. What would be the sanction for defaulters?
Generally, the Act gives the Commission the powers to make regulations in that regard. So you find that not just for limited liability partnerships or for limited partnerships, but for all entities under the Act. Before now, we had a situation where penalties, sanctions, monetary sanctions were embodied in the law. 30 years ago, I mean, you could assess a penalty of 15 naira, just 15 naira, against a company for default. I mean, if you say 15 naira per day, or even 5 naira per day, for 1 month, it was something substantial because of the value of the naira then. And over 30 years, this same amount had remained in the law. Now, that made it so clear to us that it was ill-advised, right, to continue to have sanctions in substantive provisions. The practice generally now is to move sanctions out of the substantive provisions to subsidiary legislations, regulations, so that with time, you can also move where some prescriptions have become inadequate to deter, because beyond punishing offenses, the objective of sanctions is also to deter. A system will thrive better where people don't even contravene the law, because there is a cost to making amends when you contravene. Right? There's a lot more to say for the culture of compliance than the culture of impunity, even though there are remediations. Remediations may not always assuage. So the body of sanctions now will be in the regulation. Like I said, the regulations are before the minister at the moment, and we expect that anytime now we should have it.
Mr. Tolulope Adeola, Assistant Director, Registry Department, thank you very much indeed for your time.
Thank you very much for the time.
Another key injection in the CAMA 2020 is the beneficial ownership, which not only reveals the identity of those behind companies, but also goes a long way to fight corruption in accordance with global best practice. Mr. Chidebere Nwachukwu, a legal practitioner, tells us how strategically important that provision is.
The beneficial ownership disclosure under Section 119 and Section 120 of the CAMA 2020 provides that any person who has significant ownership in any company must be disclosed by such company in filing their returns. Hence, there's this obligation on companies, which was not there before, to disclose in detail the particulars of any person that owns up to 5% of their shares in filing their annual returns. What this means is that any person filing his annual return, any company filing its annual returns as mandated at the end of their financial year, must disclose the persons who own up to significant amount of shares in the company. Section 119 and Section 120. In fact, if you read down under Section 120, Section 120 makes it mandatory for any person who is a principal officer of the company to face a penalty as may be recommended by the Corporate Affairs Commission if they fail to disclose such. Also, Section 119 also makes it also mandatory for the company to disclose within 7 days, wherein somebody acquires shares in the company, and that shares can be classified as being significant enough to hold up to 5% in the company shares. So for a company who has shareholders, maybe let's say 5 shareholders, and these shareholders own up to 20% of the shares, in that light, they must disclose their particulars in filing their returns. And if the time for the returns is not yet due, they must, within 7 days of such person or entity acquiring such shares, file to the commission the particulars of such person. So I think it is a very wonderful provision, and which is going to go a long way to fight corruption and also combat money laundering.
And this is where we draw the curtain on this week's edition of the program, CAC Weekly. We do hope you enjoyed watching. For comments and inquiries, please take advantage of our social media handles and helplines. On Twitter, it is at CAC Nigeria 1. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is cservice@cac.gov.ng. Our website is www.cac.gov.ng. And our helplines are 081-822-99016 or 081-822-98971, 090-874-01598 or 090-874-01599 and 090-8740-1600. Do join us next week for another interesting edition of the program. Same time, same station. From me, Amina Jibril, and the whole team here, it is bye for now.